Forum. My name is John Goliatino. I'm your host this evening. With me this evening is Diane Yeaman, who's been probate judge for the last, we were talking, it's hard to believe, but 20 years. She's going to give us the lowdown on what's been going on since the last time she's been here, which was roughly a year and a half ago, I guess. Right. So I want to welcome you to the show.
Thank you for having me.
Yeah, you're welcome. Now, you've been around for 20 years, and you've been the last couple of years you've been involved with reforming or reorganizing the court in the state of Connecticut. There have been a lot of different projects. You're like the chief organizer. I don't know if you're chief judge or I remember that. Could you tell us a little bit before we get into that, though? Tell us a little bit about your background, how you actually. You came to Danbury, where you're a Danbury native, where you went to law school, and a little bit about your family before we get into your probate judge activities.
Sure. Yeah, I'm a third-generation Danburian. My parents and grandparents were all born here, and I attended the Danbury school system. I went on to college at Lehigh University in Bethlehem, Pennsylvania. I studied pre-law because I wanted to be a lawyer since a 10th grade internship I had.
Really?
Absolutely.
Do you have any lawyers in the family? Aside, you know what I'm saying, before.
My father's cousins, the Gallaghers, and my husband. I married a lawyer who has a partner. His brother's a lawyer, so it does tend to run in the family, I guess.
Okay.
But after Lehigh University, I went on to law school in Macon, Georgia, to Mercer Law School, and then returned to my hometown of Danbury to practice law. And I practiced law only for about 4 years when I was asked to run for probate judge. I'm married to attorney Bob Yeaman. He's a city attorney, corporation counsel, and we have twin girls, Rebecca and Samantha, who I'm very proud of. I just love the probate practice, in the probate court system. You mentioned before about my position in the court system. Well, I've been the judge there for 20 years. I'm actually running this November for my 6th 4-year term, and it's amazing how fast it goes.
Terms. Yeah.
Yeah. But it's a state judge position, and we run every 4 years when the governor runs.
But what were you doing when you were organizing? What was that position called?
I was president judge of the Connecticut Probate Assembly.
That's what I was trying to think.
Right. And the Probate Assembly is the organization of all the judges. So I was president of the judges for the period of 2006 to 2008, which really was an instrumental period. Because all through the years before that, there had been a movement towards some consolidation of the courts. At one time, we had 133 probate courts in the state, which is more than California or Texas. And there had been a movement towards the consolidation. So during my period as president of the judges, I worked with the judges in fostering good communication between the courts, and we did some more voluntary consolidations, and ultimately ended up with 117 courts. And as we'll talk about a little bit later tonight, it's now going to be to 54 courts.
But first, let's talk about what is the probate court, what goes into the probate court. There's so many discussions about what's covered and what isn't, but people don't realize there's a federal probate, the federal process of taxation, and then there's a state process, and it's the probate court that handles both those and other duties. So what's the kind of matters that go into the probate court in Connecticut?
Sure. The Connecticut probate court system is a state court system, and we have exclusive jurisdiction over certain types of matters, meaning we're the only courts that can handle things such as probate of estates, wills, and trusts. But we also have concurrent jurisdiction, meaning we share jurisdiction with the state court system, which is your superior court, to handle other matters such as children's matters. We do temporary guardianships where a parent wants someone to take care of their child for a period of time, temporary custody and guardianship, maybe a longer period, a grandparent doing so. We'll do termination of parental rights and adoptions, so we do a lot of the children's matters. We also handle conservatorships, and that's where a person's not able to handle their affairs. We'll appoint a conservator over their finances, which is over the estate, or over the person, over their medical decisions, and that's a great volume of our cases come from those areas. We also appoint guardians of mentally retarded. If someone's over 18 and has those disabilities, appoint someone that can make their decisions for them, and a whole potpourri of other things. We do everything from name changes, we do paternity, we do permanency planning hearings for children that are in foster care and in the system. And we also
there's no movement. There are kids divorcing their parents. You handle that, or
not in Connecticut?
That goes to Superior. No, okay.
I'm pleased to report that hasn't spread to this part of the state, but But
I guess
yeah,
out
so
in
it's very wide.
California, then it works its way east.
Yeah, it seems like a lot of those laws start in California.
Yeah.
But yeah, Connecticut's probate is extremely varied. We also do psychiatric commitments, and so it's a little bit of everything. It's not just the wills and trusts that you think about.
Okay. And we talked a little bit about the consolidation. Now, the assembly, as you were saying, is 100. There's 117 current
Right.
courts.
Currently, it's 117 probate judges, and when you become elected as a probate judge, you automatically become a member of the Connecticut Probate Assembly. So that's one of the organizations. And the Assembly is very active. We meet by bylaws. We meet 5 times a year at a minimum for educational purposes. We also have multiple committees. And when I was president of the judges, you appoint the committee chair and you make sure all those committees run smoothly. Legislative committee over probate legislation. There's also committees over education, ethics committee. So it's many, many faceted, and it really deals with all the different areas.
Okay, now, I guess what is going to happen this year? Someone said recently, in fact, before the show started, somebody made that comment that it might be better if you died this year as opposed to next year, but I guess, I don't know, I wouldn't want to find out that early. Give me another 30 years or more, you know. But is there an advantage to this year? And that has to do with the federal law, right?
Right. You're talking about the federal estate tax.
Yeah.
In Connecticut, we have a Connecticut estate tax.
Right.
And currently, the exemption as of January of 2010 for any deaths after that time, the exemption for the Connecticut estate tax is exempt for any estates of $3.5 million or less.
Right.
But the federal estate tax, back in 2009, it was also a $3.5 million exemption.
Right.
And we were hoping that it'd be hand in hand with Connecticut with both having the same exemption from this point forward. But unfortunately, the Congress did not take steps to have that stay in effect.
Right.
So essentially what's happened is for the year 2009 it was a 3.5 exemption. 2010 was a good year to die because there's no estate tax, federal estate tax this year.
Right.
And then next year we were hoping they'd go back into Congress and raise the exemption level back up to 3.5 or some other level.
Right.
But failing that, it'll then 2011 that exemption for federal estate tax will go back to $1 million.
A million or 650,000?
So they're looking at it. We're hoping they're going to still do something with it. But essentially,
but it was 650 when they started.
That's right. So go back to where they started and take it from there. But it's awfully
awful low. You hit even middle-class people at that level.
Sure. And absolutely. And so that's why 2010 they kind of joke about it being a good year to die. But
So the feds sort of like use the probate court as the conduit for, okay, you figure out this is what you owe in tax when somebody dies. You administer all of the monies as they come through. Let's say a husband and the grandfather died. Now the grandmother's alive and she's finally gone.
Right.
And the assets come. How do you? Let's say there's an executor.
Sure.
All right. So what do you do when the executor comes to you? He says, what do I need to do? There's 3 bank accounts, there's a house, maybe it's $1 million, maybe it's only $500,000, but how do you guide someone like that in a typical situation?
Well, first of all, we have to determine, they have to find out what are the solely owned assets of the decedent. Because what passes through probate are the solely owned assets. Those are what are put on the inventory, and those are things that the court orders to be distributed. Because don't forget, joint property, survivorship property, goes automatically to the survivor on those accounts. Although you do have to still list them, all those joint accounts and life insurance and other things all get listed on that estate tax return.
To come up with the size, the total size of the estate.
Correct, and probate fees get based on some of that.
Right.
But essentially, the first step that we do is we try to determine if the solely owned assets are above $40,000 or under $40,000. Because if the solely owned assets are under $40,000, there's a small estate procedure that doesn't even require a hearing, where they can file the paperwork, have it processed through the court, along with the estate tax return, death certificate, funeral bill, and all those things. And we just process that paperwork and order the solely owned assets to be transferred according to the will, if there is one, or according to the laws of intestacy if there's no will. But if the assets are over $40,000 solely owned,
right,
then there is a regular probate procedure for regular estates where they'd have to have the will admitted, file an inventory, at the end, file your tax return within 6 months. That was a change in the law. For deaths after July of 2009, those Connecticut estate tax returns are due within 6 months of death. It used to be 9 months. But
they need the money for the tax,
Absolutely.
Got to keep the machine going.
Yeah. But based on the assets, we determine which procedure they're going to follow.
Okay. So you guide people along even when there's confusion or whatever, and it gets a little more mixed up when there's a mom and dad and there's younger kids, they're let's say under 18. What would be the difference there? Maybe the same situation, $500,000 of assets. If there's a brother or a sister on one side or the other, do they automatically get appointed? Let's say there isn't a will.
Okay, yeah, those are difficult situations, and if you have a mom and dad have passed away.
In a car accident or whatever.
Sure, absolutely. Yeah. And that's why the wills are so important. But if they don't have a will, then essentially any family member can step forward to be appointed guardian of that minor child until they reach the age of 18. And those can be difficult because you may have both sets of grandparents coming in, you may have aunts and uncles, or even siblings of the child, all wanting to be guardian of that child. So the other thing that is involved, without a will, minors, attain the age of majority at the age of 18. So if you didn't have a will with a trust provision, any of those children, once they each reach the age of 18, will inherit all those assets, which isn't always the greatest thing to do. Their level of maturity may not be such that they can handle it.
Some kids are mature, but other kids are not mature, and they 18. Oh boy, I'm getting $100,000. I'm going to go buy a Maserati or something.
Right. And without a will that provides a trust for that child, there's nothing the court can do.
Right.
So I think that's another reason to have.
But if there is a trust, there's no way that the kid can change it. This is the way it was set up. You get your money over a course of 10 years, or you get it in 7 years or whatever, a little at a time, and that's the will of the person that died. And it's also like a spendthrift provision that that maybe they'll be wiser if they get it over 7 years or 10 years.
Sure, and I think that's part of the planning process.
Right. Okay. Has there been anything unique like that lately that you've seen? Without mentioning any names, of course.
Sure. Yeah, I've seen many cases where people just haven't planned, where they'll come into court, or they just have avoided probate over the years, and now they're going to be selling the family home, and dad died back 5-10 years ago, and they just never went through probate. Even with jointly owned real estate, you need to go through probate in order to have the deceased person taken off that property. You have to file that tax return so the court can issue something for the land records. And it's going to be more important than ever to kind of follow through with probate sooner because of a change. One of the changes in the laws that took place in this past legislative session is they're going to now put late charges on your probate fees that are being paid late. So if the tax return should be filed within 6 months of death, and the probate fee gets calculated at that time.
So if it's 10 years,
10 years, you have a lot of probate fees, late charges that have incurred.
Is it possible that an estate could be gobbled up?
Hopefully the amount of those late charges won't be that exorbitant, but it is something that the legislature has put into effect. So I think I'm going to try to get the word out that if someone passes away, just at least inquire if you need to go through the probate process, because if you wait a long number of years,
so it's that 40,000. And that should encourage a lot of people that have people in nursing homes and whatever. And let's say there's 20,000 left or something. They don't have to worry about not paying a tax. There probably isn't going to be any tax.
But it's the probate fee that there would still be a probate fee if there's some assets being transferred, or even a joint house.
Right.
There would be still some probate fees, and those would incur late charges if not paid. So that's something important to think about, and to make sure that people are a little more timely in coming forward and just getting that paperwork done on time.
Yeah, that's true. Of course, it's all about revenue too. So,
unfortunately, but luckily, Connecticut's very user-friendly. You can even go through probate without an attorney in some of the more simple estates.
So, your recommendation then is that any type of situation, what if a person's an individual and doesn't have any relatives to speak of? You still should have some kind of a will so they know what do you want done with your money, even if it's given to the United Way or something,
Sure.
right?
Oh, absolutely.
Yeah. So most people should have a will.
Yeah, and if you have no relatives, the only time a state gets it if you have absolutely no relatives at all, not even a third cousin twice removed. And there's genealogical search firms that come in when they see these types of estates happening, and they take a certain percentage of the estate in order to help find some distant relatives. But you'll have people inheriting from an estate that have never even met the decedent. So I think that, you should be, in your will, helping and your neighbors, people that have helped you during your lifetime, give charitable gifts and things of that nature. Otherwise, if you don't have a will, it does go according to Connecticut laws of intestacy, and it might be going to some very distant relatives that you maybe have never even met.
Okay. Now, we covered the realm of somebody, let's say, gets injured or something, and let's say he's got 2 kids and he's in the hospital, and they don't expect him to recover, or they expect it's going to be a long process, but there's 2 kids and there's no known relatives. You've looked around, the police, let's say, has looked around, he's had a terrible accident or whatever. Is it called a conservation? So who do you appoint as the judge? Because the police then will bring this to you, or someone
Sure.
Will bring this to your attention, right?
Yeah, that happens, and
Yeah.
it does happen. What happens in those cases, first of all, if a person really wants to plan well, they'll have a durable power of attorney and a power of attorney for health care, so that if anything happens to them, then that durable power of attorney can step up and make health decisions and other decisions.
So those are documents. If it is a single dad or a single mom and they have a couple of kids, they may have that in a safe deposit box or in the let's say a metal box, locked up at the house or the apartment or whatever. So someone could say, hey, there's something here of value. Let's see what's in there, and that would indicate. But if there isn't anything there, then the judge...
Then it's a conservatorship. And anyone can apply, any interested party can apply for a conservator. We get a lot of our conservatorships, the Danbury Hospital applies, because it's a situation where there is no family to step forward. And in those cases, we always look for family first. But if there is none, then we do have a panel of attorneys who are willing to serve in that capacity, and we can appoint an attorney as a conservator of someone's person or estate. I have some retired nurses and others from the community that serve in those positions, and they're accountable to the court for all that they do as conservators. And we can do it on a temporary basis as well. And even between spouses, I have to mention that. And we had a case just last Friday, and the family said I could tell their story without any names, but a gentleman fell and had a traumatic brain injury, and he had never done a power of attorney to his wife or anyone. So now he's in the hospital, and there's no one to make medical decisions. He's completely unable to make any decisions or to handle his financial bills or insurance. And the wife makes calls to the insurance company. They won't talk to her because she doesn't have power of attorney. So that's a true instance that it would have been helpful to have those documents. But the court was able to appoint the wife as a temporary conservator. We did it as an immediate ex parte decision where there wasn't a hearing. I just was able to do it on the spot in the court the same day. And then the law requires a hearing within 3 business days, which we held today, and the court confirmed that appointment. So with the temporary conservatorship, which is effective for 30 days, that wife is able to immediately jump in and make all the decisions that she needs to make. So that's a very important role of the court, to be able to appoint people in those critical situations.
Now, for the general person that's out there, whether they have an apartment, they have 3 kids, it's a married couple with that same situation, they might be wealthier, they have a full family out there. I think the uniform thing is everyone should have at least a will. What else should they have with the things that go on today? I think you already mentioned it, but just want to impress that on the viewers that it's just not a will alone, which runs what about? What would you say if you're going to the range?
I'd say a couple $100s to a little bit more, for more expensive
depending on
depending on if there's trust provisions and whether there's tax planning, and then they could run more.
The more paperwork, the higher it is, but you could say
Absolutely.
that 200 is a base of most of the
Well,
attorneys.
I'd say probably $400, $300, $400 perhaps,
Yeah.
ranging upward for more complicated wills.
Okay.
But there's really 4 documents we generally advise. The will is one of them, naturally. Durable power of attorney, I mentioned, which appoints someone to handle financial affairs, health insurance. And by the way, 2 years ago, the legislature changed the durable power of attorney. You used to have healthcare decisions as part of that document.
Right.
Now they've separated it out, and you have to have a separate healthcare power of attorney.
Okay.
So those documents before 2008 are grandfathered, and they're still good. But anyone that does power of attorneys now need one for healthcare and one for everything else. And
So the one for finance, one for health.
right.
And then
lastly, a living will. If you don't want life support machines, if you're in a coma, that living will lets the doctors know that you don't want the machines and the respirators if you're in a terminal vegetative state. So that's an important document as well. And if you have that, they usually have it right in your medical chart at the hospital so that they're aware of your wishes. And those type of documents shouldn't be in a safety deposit box. They should be, your family should be aware of them, your doctor should have them in your family physician's chart.
well, here's something I do for insurance policies. I'll say make a copy of everything. And keep the original in the house where people can find it, but you got a copy in the box, so if they get burned up, you got a copy of everything there also.
Sure,
in
absolutely.
a safety deposit box. But you got a point there, without those being readily available somewhere in a desk or something in the house, how are people going to know where they are? They'll have to
Exactly.
start looking around for a key or whatever.
Exactly.
Yeah. Okay, so that applies to regardless of who it is, would you say, or guy's got maybe $100 in the bank and
You still
all
need someone to make healthcare decisions. If you're in a state that you're not able to make them yourself, the doctors cannot just listen to someone or even a relative. So I think no matter what your financial situation is, I think that power of attorney for healthcare is a critical document to have. And you can even have more than one person named. So if you have multiple children, they can all, hopefully they all work together on those issues.
Right.
And if not, then sometimes it does end up in a conservatorship if you have power of attorneys, multiple ones that don't get along with each other and aren't doing consistent decisions. You may end up with a conservator anyway.
Now, the last time you were here, you're talking about increasingly you're having a lot more kids coming into the court, one way or the other. They're not divorcing their parents in this state, but there's all kinds of situations like that. You have any recent things that you could share with us? Because they're always interesting. Oh, geez, I didn't know that could happen,
Sure. Yeah, there's many children's matters in our courts. Not only are the cases where we have guardians, we're seeing many grandparents, probably even more than we used to, where the grandparents are taking care of their grandchildren, and there's just an increasing number of those cases. We're also, and we always have had cases in Connecticut, if a minor receives more than $10,000, then a guardian has to be appointed over their estate to handle the funds, and they have to account for it every 3 years till the minor's 18, and then the money is no longer, through probate. So that's another aspect that we see a lot of children. We also have a lot of permanency planning hearings. If a child is committed to Department of Children and Families on a voluntary basis, because a family may have a troubled child, they may have bipolar or some mental health issues, attention deficit, or...
Of course, they may have problems, too.
And
the parents, parents might have done something wrong, or drug users or whatever.
Sure.
They go to Children's and Families AIDS, right?
And there's a lot of support in the area, but those cases come to our court as well, where we have hearings to just make sure the planning is going well for those children, and that they have the support available that they need. Danbury's a great community. There's just a wealth of support out there. The agencies really work together in the best interest of children, so we're very fortunate.
Now, do you have anybody out there that, let's say, works with you more than the next lawyer? I mean, are there certain lawyers that are like specialists? Or, in other words, let's say you're out in the community there and you're trying to decide, okay, do I go to the probate judge by myself, or do I select a lawyer out of the yellow pages? How do I go about this? Is there some kind of designation after the lawyer's name, or is it in their ads that they specialize in this, or can most lawyers come to probate and know what they're doing?
The process is simple enough that it's very user-friendly, and people can access the system themselves without attorneys. So I think that if they have simply a bank, their mother died, they have a bank account, they have a piece of real estate.
That's what I'm talking about.
Yeah, they might be able to go into court and do it themselves, but if they feel they get to a point where they're a little overwhelmed, we're not able to steer them to particular attorneys. But pretty much, like you said, with their advertising and all, attorneys will indicate if they're specializing in certain areas.
If you're still using the Yellow Pages, a lot of people go on the computer and punch up names. But,
right, that too.
But I'm saying is if you go to the Yellow Pages, it could be anybody there because most attorneys can do this. But on the other hand, just like you said, if it's simple enough, it's not a complex situation, they should be able to do it themselves for the smaller cases, right?
Right, and all the forms are online. There's a judicial website, which is...
What is your website?
It's the judicial website is www.jud.ct.gov/probate.
Okay.
So it's again www.jud.ct.gov/probate.
And do you put anything to get to the Danbury court? Is there Danbury after that?
Actually, there is. It does give you a directory of all the courts, and it goes through all the probate court forms are all on there.
That brings you to the state.
Brings you to the state, and then you can get a directory. But all the 117 courts have the same probate forms.
So all the forms that you need to file.
Yeah, everything's consistent. So you can get into there. There's also some excellent questions and answers. There's also some booklets that can be downloaded, like an 8-page booklet about what is a conservator, what is a guardian, and so all that information is all accessible online. And those booklets are available if you come to the court. If you don't use a computer, certainly they can come to the court and just get the forms from any probate court, and they can file them in any of the probate courts.
Okay, and what's your probate court, your court, the telephone number?
Yeah, the Danbury Probate Court is 203-797-4521. Again, that's 203-797-4521. And
now, at this point in time, is there any particular day that you're in there, as opposed to, I think it's like 3 days a week you're in there more often than not? Or?
Sure. The probate court is open similar to City Hall. It's a 4-day work week at City Hall because the energy saving, we're closed on Fridays.
Right.
And the hours are 7:30 to 5:30, Monday through Thursday. And I hold hearings all day Tuesdays and Thursdays, and the other days, part of the day just to do signing, write decisions. And Friday I'm in my law office, and I often get called for probate emergencies on Fridays.
Okay.
But I'm always available, just like this past Friday.
Okay, so if there are people who are going to call you with a problem that just want to sit down with you, let's say they're doing something themselves because they've gotten a bank account, they got something simple, but they have some questions, they can set up an appointment on those days, like not Tuesdays and not Thursdays. Those are the days you're available.
Actually, any of the 4 days, the clerks, and each of the clerks have got specialties in different areas that they handle, such as Jessica that does the estates, and Bernice does the small estates, so they would meet with them.
They're waving to me. We got to go.
Okay. Thank you so much. It was a pleasure.
Thank you for coming on the show, and thank you to the viewers for coming to Community Forum. We'll see you next week, same time, same station, and I'm sure we'll have another interesting program. Good night for now, and we'll see you then.